This is fascinating. You'll recall sometime, I don't know, a year or two ago, Phyllis Schlafly was on this program, and we were talking about the Supreme Court. And I asked her how, if the president doesn't like the Supreme Court's decisions, what can he do? And she said he can ignore them. She said, this is what Abraham Lincoln did. Now, I didn't know this before Phyllis Schlafly informed me about it, but I went out and I did a fair amount of research on it, and sure enough, she was right. And what Lincoln said in the Dred Scott case, Dred Scott was a slave who was free, whose owner had taken him to a non-slave state where technically, I believe it was Illinois, where technically he was eligible for freedom. No, it might have been north of that. It might have been Wisconsin or well, I'm not sure. Minnesota could be. But in any case, in the Dred Scott decision, basically Roger Taney, the Chief Justice of the U.S. Supreme Court, said, sorry, Dred Scott, you are the property of Mr. Sanford. And what Abraham Lincoln did, well, here's this is from today's New York Times piece. In his first inaugural address, Lincoln discussed a recent Supreme Court decision about slavery. That would be Dred Scott. He forswore any assault upon the court, but stressed that, quote, the policy of the government upon vital questions affecting the whole people ought not to be irrevocably fixed by a single suit brought by only a few. Really? He said that the Supreme Court opinion were ultimately limited to the parties to a suit as to the object of that suit. In other words, here's a quick and dirty for what Lincoln said about Dred Scott. He said, Mr. Dred Scott, it's really sad that the Supreme Court has ruled that you are still the property of your former owner. But that's only true of you. It's not true of anybody else. In other words, the Supreme Court decision only applies to the person who was before the court. Dred Scott lost, so it would only apply to him. Similarly, what William Baud is writing about in today's New York Times, and he says it just very, very straightforward. He said, in the King litigation, what he's suggesting is that the president say, okay, cool. There's 4 parties in this King v. Burwell suit. If the 4 parties on the King's side win, if the Supreme Court rules in favor of King and King v. Burwell and says, okay, we're going to strike down Obamacare, the administration should say, okay, cool, those 4 people just lost their Obamacare. And the reason why he says that this is the way that William Baud says that this is who's by the way, a assistant professor of law at the University of Chicago. The reason he says that this would work is that then everybody who wants to get out from under Obamacare would have to bring a lawsuit, right? And the fact of the matter is, most people are not going to do that. Who's going to sue and say, no, I don't want help from the government? Right? It's like somebody bringing a lawsuit saying, no, I don't want those Social Security dollars. It's just, it's pretty much not going to happen. Or if it happens with 10 or 20 or 30 people, then, okay, cool. The 10 or 20, 30 people get out from under, the requirement to buy health insurance. But it's not going to be a big wave.